Hi, my name is Kim Schutt, and this is my Module 12 on tort liability. So first we need to talk about what is tort liability. The best definition that I found says it's a civil wrong for which a remedy may be obtained, usually in the form of damages, and then we'll talk about the two different types. So it is a state law. It states individuals are liable for their consequences and that teachers are liable for acts caused by another student while under their direct supervision. So the two types are intentional and negligence. So in an intentional tort, the offense is committed by an individual with the intent to do harm to another person, or the understanding that their actions might cause harm. So if they purposely, say, hurt somebody by getting in a fight. So battery, slander, assault would all be examples of intentional. For negligence, this is the failure to exercise the standard of care. So a good example for this would be anticipating a foreseeable risk. So say there was a safety concern in a classroom that the teacher knew about and that they didn't go back and correct anything. Someone could have potentially gotten hurt by that and no action was taken to prevent it. So looking at the 5 different cases, the first case is actually a local case here in Colorado with the St. Vrain Valley School District versus Loveland. So in this case, there was a 9-year-old girl who fell while using the playground zip line and severely fractured her wrist and forearm. This was a really long case, and I actually learned a lot, even just with laws pertaining to Colorado, one of them being the Colorado Governmental Immunity Act, or CGIA. So I did my best to summarize it, but it was pretty lengthy. So long story short, there on the playground with the zip line, there was a sign warning students that adult supervision was required. But Alexa, the 9-year-old, didn't follow that sign and didn't ask for an adult to come supervise her while she was playing. So apparently, in Colorado, public schools are immune from tort liability under the CGIA Act. So in this case, it kind of went back and forth a lot between the district and the parent, but they deemed that the zip line was not in dangerous condition. The family couldn't prove that it was working improperly or that there was a malfunction. It was just bad timing that she happened to fall and there was no adult supervision. So under the Colorado Governmental Immunity Act, they couldn't deem the zip line dangerous. So the results were that the family couldn't satisfy the dangerous condition requirement that is set under the CGIA, and the district won this case. So as far as a reactive response to this, I think first and foremost, any staff in the area need to immediately take care of the student who's injured and contact the parents about what happened. To be more proactive, I mean, again, just knowing that the CGIA protects public schools from tort liability is important as an administrator. Even though there is a sign that says adult supervision is required, I think for something like a playground, especially a zip line, you should just always have an adult supervising and being proactive for that. And then just checking generally the playground for safety. So maybe, again, if it was in dangerous condition, they need to be proactive and they need to fix whatever is maybe wrong with that device. And for professional ethics, I think a lot, again, just goes back to, as a staff member, if you noticed a student on, say, the zip line going over there and being that adult presence, knowing the laws, again, with CGIA, there's a lot to it, but just kind of keeping up to date with that information could be really useful. In the second case, it was Mitchell versus Cedar Rapids Community School District. This case was really troubling to me, but there's also a lot of dynamics too that I feel like maybe wasn't handled correctly. So basically the background with this one, a mother of a special needs student is suing the district for damages that the student sustained, both after hours and off campus. This special needs student was sexually assaulted by another student at the school. Again, long story short, the 2 teachers who were working the closest with this special needs student said that they had noticed previously that she had been interacting with another student in her grade. They had been seen like holding hands and kissing, and it seemed like they had been in a mutually agreed relationship, and that these teachers usually have those conversations with their special needs students surrounding the topic of relationships. On this particular day, both of the students decided to ditch their 6th period class. And in this case, at the school, parents get kind of like a robo phone call policy as far as attendance, stating that the student missed a particular class. There wasn't immediate follow-up on the end of the school or on the end of the 6th period teacher when they noticed that the kids were ditching or that the kids weren't present. And basically, again, long story short, they weren't fully aware of like her IEP status, and there probably should have been a phone call home. And in the end, the mother ended up winning in this case. So reactive, I think, again, it's hard when you have a large class and maybe you're not fully aware of IEP status, but just asking information from all students involved. It had briefly mentioned in the case that there was another student who walked home with those students and saw the rape happen, but never reported it. So just trying to get as much information, maintaining accurate attendance at the beginning of every class, making sure that you're taking attendance and being in touch with the parents as soon as possible. I think reporting any suspicious behavior, it wasn't really indicated other than that student who went home with them, that anybody else at the school or teachers were aware of what was happening. And then to be proactive, I think first and foremost, just maintaining open communication with parents. I mean, obviously following the IEP guidelines very closely and being aware of that. I feel like those two teachers could have handled it better. It said in her IEP that she was allowed to be on her own, but it wasn't very often that teachers left her unsupervised. So I think just following up with that too. But just first and foremost, open communication, showing professional ethics as far as maybe making that phone call home, and just checking in with the students. In case 3, this is Munn versus Hotchkiss School District. With this is one that concerned me a lot too, because I do a lot of traveling with students through my student-led organization called FCCLA. We do in-town trips, in-state trips, national trips. So this one kind of touched home for me a lot. But basically the background for this one is there was a 15-year-old student who was bitten by a tick while hiking in China during a summer trip, which was organized by the school. Unfortunately, the tick transmitted a virus that caused serious neurological damage, leaving her permanently unable to speak. So in this case, the parents were suing the school. They felt that they were negligent by not warning parents or students about potential disease-bearing insects in the area that they were traveling. And when they were there traveling, the teachers and administrators failed to take protective action for the students, so maybe encouraging them to wear insect repellent or just really kind of educating them on the environment and the area that they were in. So this essentially ruled out. The jury awarded the family $10 million in economic damages and about $31 million in non-economic damages, which is a significant amount of money. Obviously, this is a really serious case. And unfortunately, the student ended up having long-term permanent damage. But I think it's something, too, that if you're being proactive, which I'll talk about in a second, there are potential ways to avoid the lawsuit. So if I was caught in this situation, I think just an immediate reactive response would be to contact the parents immediately after the incident occurred. Try to get the student treatment because, again, right there in that moment, you're not sure exactly what's happening, but trying to get them the medical attention that they need. I think to be more proactive, you really need to do a lot of research as far as where you're traveling. Like they had mentioned, maybe being aware of more of the insects or just animals in that area that could be dangerous. I think putting together, and this is something that I do when traveling with students, just having a parent meeting, really documenting everything through permission slips. If it is necessary, maybe students need to go to a doctor or see a healthcare professional before traveling, and just having those conversations with parents before leaving for the trip can make a big difference. Therefore, everything's just laid out. You have parent signatures and they're aware of what's going on. So again, just going back to communication is key, following those district guidelines as far as permission slips and knowing what you need to know ahead of time when traveling with students. In case 4, this was Johnson & Johnson versus the School District of Millard. This is another one. This is an example, I feel like, of a case where teachers don't always see every little thing that's going on in their classroom, especially when you have such a large class. So in this case, a first grader got injured while attending his music class. The teacher had been having students participate in a London Bridge activity where they had to like hug hands with other students. And it seems like two of the boys who were involved with this incident maybe were a little rougher than they should have been with the other student. They ended up throwing him into a bookcase, and the student who was injured suffered a large cut like right above his eye and needed a bunch of stitches and had some long-term like vision damage as well. So in the case, it said that the teacher had her back turned when the incident happened, just writing on the board, and the family sued for negligence on the part of the teacher. And then in the end result, the teacher was held liable for over $20,000. So this is another one. It makes me nervous as a teacher. Like I said, especially I teach a lot of culinary arts classes with a very small room and about 25 to 30 students in a class. And when they're working with dangerous materials like knives and hot water and ovens and stoves, there's a lot that can happen in a short period of time. So a reactive response, I think from an administrative standpoint, you would want to remove the teacher until the court case was complete. She's probably not going to do a great job continuing to teach at that moment when she knows that this is going on. I think also in this case, just getting the teacher's perspective, talking to other students in the classroom about what had happened and the two boys that had injured the other student. A more proactive approach would be reviewing with all staff supervision policies, reviewing school board policies regarding neglect. Again, just making sure that everybody's on the same page, making sure, not that she did this in this case, but making sure they're not leaving the classroom unattended. And then just from a professional ethical standpoint, understanding laws and policies regarding the safety and supervision of children. Like I said, you can't always see every single thing that's going on, but just making sure that you're communicating those policies and that your staff is on the same page to ensure that students are safe. In the last case with Commonwealth versus Lambert, this is a case too that kind of struck home, that really surprised me that something like this would happen. But the background for this one is a preschool special education teacher was convicted of assault and battery against a child with Down syndrome. In this situation, the student was getting off of the bus, had handed the supplies or their supplies to another teacher, and this teacher didn't feel like that was appropriate. So she forcefully pulled the student by their wrist to get her belongings from the other teacher. The teacher who did this was not aware of the student's individual education plan, and there was actually another teacher who witnessed the whole event happening but didn't feel comfortable going up and intervening because she knew what was happening was not appropriate and she didn't want to get in trouble as well. So in this case, Lambert, the teacher, was found guilty and was sentenced to 30 days in jail and 30 days suspension from the school. So a reactive response, I think as an administrator, as soon as you find out that this incident happened, you have to call home explaining, being, I guess, proactive but reactive, but explaining what had happened in that situation. Obviously check that the child is okay. They maybe got physically hurt, emotionally hurt, and just doing that check-in can make a big difference. A more proactive response, again, is just to properly train teachers and staff, especially when we're talking about our special needs population, making sure that they're training or they're getting trained properly on like certain holds or restraints and just healthy boundaries with students. I know in Poudre School District we have different trainings and different seminars we have to talk or go through to learn about proper restraints of students. And then just like with every case, again, just maintaining open communication with all stakeholders involved, and then speak up if something's happening. I get where maybe that other teacher is coming from, that they didn't want to also get in trouble, but in this situation, we need to be looking out for what's best for students. And if I was in that position, would definitely have said something. So overall, I enjoyed this module. I learned a lot through reading through the cases, and thank you for listening to my presentation.